Hello, everyone. My name's Edward Davis of Secor Law in Miami, Florida. I'm the former executive director of the International Chamber of Commerce FraudNet, which is a group of lawyers that specializes in representing victims of fraud around the world. Joining me here today for this brief overview of a new Supreme Court ruling is my good friend and colleague, Thomas Van den Abel.
Hi, I'm Thomas Van den Abel from the New York law firm Kellner, Hurley, Gideon, Friedman. Just like Secor Law, we're very much involved in asset recovery, and I'm a proud member of ICC FraudNet Future. The senior partner and founding member of the firm, Douglas Kellner, has been a longtime member of FraudNet. Very happy to be with you today.
Great. Thomas, we're here today to discuss a new development in the law, and we're going to briefly do an overview of a brand new case from the United States Supreme Court called ZF Automotive and its companion case, Alix Partners versus Fund. And this case involves the use of 28 USC or U.S. Code Section 1782. And so I'd like you to give a brief overview of this new development in the law.
Yes. So first of all, let me explain that 28 USC 1782 is a very powerful federal statute, a powerful tool that allows foreign litigants to obtain discovery in the U.S. for use in a foreign and international tribunal. And this is where the decision is of significance, is as to the definition of foreign and international tribunal in the statute. It's always been understood that a foreign court falls within the ambit of a 28 USC 1782 application. However, it wasn't so clear whether a private arbitral panel would fall as well. And in fact, there was a split between the circuits. By this decision, the Supreme Court has resolved the split and has clarified that a foreign or an international tribunal under statute is an adjudicative body that it exercises governmental authority. That is the bottom line. I could go into more details, but that is the bottom line. And so a purely private arbitral panel is no longer going to qualify to obtain discovery in the U.S. as per 28 USC 1782.
So this is a significant development in the international arbitration world, but your firm and my firm do cross-border asset recovery. In fact, we've collaborated quite a few times together as firms with regard to the use of 1782. And so I'd like you to give us your thoughts. Can and does this new ruling by the Supreme Court in any way impact the use of 1782 with regard to cross-border asset recovery?
No, absolutely not. This decision does not alter a prior decision of the U.S. Supreme Court, the famous Intel case, I think of 2004, where the Supreme Court had sort of maybe not expanded, but at least clarified the statute to include reasonably contemplated proceedings. So it's not only foreign proceedings that are pending, it's also a proceeding that you, the client, may be contemplating. You may think you have a claim somewhere and you need discovery that may actually help to prove this claim. Well, you can actually do a 1782 and you can still do it. This decision does not impact in any way whatsoever what Ed and I have been doing, except to the extent that I mentioned, that if your clients maybe by contract has agreed to resolve any disputes he or she may have in a private arbitral panel, well, in that case, and only in that case, a 1782 may no longer be available.
So this very powerful tool that allows the cross-border acquisition of evidence in the United States for use in proceedings abroad, in your opinion, remains very much alive and viable, in my opinion as well, for use in asset recovery and cross-border cases, correct?
Absolutely, and as a matter of fact, I'm working on my next 1782 that we are hoping to file in a couple of weeks. So no, it certainly does not deter me. I still think it's one of the best tools for my clients to recover their assets.
Funny you should say that. I'm doing the same. So we will be collaborating on that again. So Thomas, really appreciate your time today in giving us a quick overview of this new landmark decision under 1782 and how it might have impacted, and in fact, we now feel very comfortable saying really did not have any meaningful impact on the asset recovery practice or the use of it in an asset recovery case. So thank you so much.
Thank you, Ed, for the opportunity. My pleasure.
Finally, I'd like to recommend that any victim of fraud, whether you be an individual victim, a corporate victim, or any other form of entity, reach out to a ICC FraudNet member for assistance with regard to understanding the fraud, investigating the fraud, and recovering the assets or the value that was taken from you. This is a very complex area of the law, and it is very critical that at the very beginning of when you first learn of a fraud, that you reach out to a professional that deals with these issues. And ICC FraudNet members like Thomas and Doug and his firm and myself and many others specialize in rapid deployment of our skills to try to maximize the chances of recovering assets when you are a victim of fraud.